All right, we're about to be ready to go. Are you ready to go?
I'm ready, Your Honor.
Excellent. Okay, let's get on the record in 2022 EX 000024, which is the special purpose grand jury. It is about 2 o'clock on the 21st of July, and we are going to work through this afternoon a couple of motions that have been filed. A motion filed on behalf of Senator Jones seeking to disqualify the DA's office from handling the case, at least as to Senator Jones, and then a motion to quash and disqualify, but the disqualify, I think, is merely an adoption of Senator Jones's motion that was filed on behalf of 11 of the, for today, we'll call them alternate electors. Those are the two motions I think we're covering. The state has filed, the district attorney's office has filed an opposition to the motion to disqualify. I let them know because of when I received the motion to quash that they didn't need to file a written response, which is fine, but hopefully you're able to address it today. There's a lot of moving parts. We've got a lot of lawyers here, so I want to make sure we get on the record who is here and who will be speaking for the different parties. Before we go any further, though, Rule 22 wise, there were some media outlets that only reached out today to get the green light. If you were able to get equipment in here, you're free to use it. But I didn't sign your Rule 22s today because the general rule is 24 hours in advance. But you really only need the Rule 22 for purpose of getting in the building for the big cameras. So if you sought Rule 22 approval to record things while you're in here and you've got a handheld device, you are welcome to do that. Going forward, it's 24 hours in advance, and it would really help if you could report back to your Rule 22 people if you would designate more clearly on the Rule 22 forms what kind of equipment you want to bring in. I am all for having a pool feed rather than 4 big cameras in here. It gets a little crowded for you all. But I can't tell because everyone who submits a Rule 22 checks I want to bring every kind of equipment on I'm bringing a drone. I know you're not bringing in a drone, but apparently 4 of you wanted to bring in the big cameras. We only need 1. And like I said, I'm happy to have a pool, but it's hard to tell. All right, with that, let's start with the state. Who will be handling, it can be more than 1 person, but I just don't want to omit anyone if I'm looking to the district attorney's office for answers or responses to concerns raised by some of these witnesses. Who from the DA's office or affiliated with the DA's office should I be expecting to hear from?
Good afternoon, Your Honor. I'm Anna Green-Cross. I'm here representing the district attorney's office on the motion to disqualify prosecutors.
So if I have questions about quashal or assertion of Fifth Amendment rights.
Good afternoon, Judge Nathan Wade, Special Prosecutor for Fulton District Attorney's Office, as well as Donald Wakeford.
So Wade and Wakeford for Fifth Amendment quashal, Green Cross for the disqualification.
Yes, sir.
Got it. Thank you. All right. If we pivot over to witnesses, potential witnesses and counsel, Mr. Dillon, how are you, sir?
Good afternoon. I'm fine, Judge.
You are representing Senator Jones. Anyone else that I don't want to ignore anyone?
My associate Anna Clapp is also here.
Great. Okay. Clap as in applause or plat as in like, all right. Got it. Excellent. And then on behalf of the 11 alternate electors, Ms. Pearson and Ms. Dubrow, I see Ms. Dubrow virtually. She is appearing hopefully in Noonan or even further away. But we green lighted that virtual appearance is fine. And we've got Ms. Pearson here. Okay. Anyone else on behalf of your clients or just the 2 of you? Okay. All right. So I want to start with a question for either Mr. Dillon or Ms. Clapp, and that is whether you are joining in the motion that Ms. Pearson filed in which Fifth Amendment concerns are raised as opposed to conflict issues.
Yes, Your Honor. Insofar as Ms. Pearson's motion, I believe at page 7, raises the fact that these witnesses who have received both subpoenas and target letters should have their appearances waived. We join in that portion of our motion.
And what is the status of your client? I know he's received a subpoena. That's the only part that's been disclosed to me.
Well, in the government's response to our motion, they actually point out that Senator Jones received a target letter in this case.
Okay. Do you disagree with that or?
No, I do not.
Okay.
It's
All right.
an irrefutable fact at this point.
Okay. Got it.
We publicly acknowledge that it is an irrefutable fact.
Okay. So my thought is that we talk about some of the Fifth Amendment concerns first, because it may make moot for practical purposes the conflict concerns that you raise in your motion. And let me simplify my thought process for you. If in the end I determine that Senator Jones need not appear because of Fifth Amendment reasons, I don't know we need to reach the question of disqualification if that would be his only connection to this grand jury. This grand jury is not a grand jury that would be voting on a bill of indictment. It is a grand jury that has been tasked with generating a report that will contain in it, ideally, a recommendation to the district attorney as to whether she should pursue charges or not, and what those charges might look like, and any other things that that grand jury wants to put in there other than a true bill. So if the way the Fifth Amendment analysis plays out is that I conclude that Senator Jones doesn't need to appear, maybe other than to state his name or something, and we would work through those logistics probably in a smaller group setting. Do you agree that we don't need to reach the question of disqualification?
No, Your Honor, I do disagree.
Okay.
I think that the disqualification issue is right. And I think that it has been exacerbated by the media circus that's been generated out of the Fulton County DA's office in this case, and that the harm to my client, to Senator Jones, is that he's being dragged through the mud publicly as a subject of this special grand jury.
Well, apparently as a target, not a subject.
I say as a subject, as somebody who is affected by this special grand jury, particularly as a target. But with the effort and focus being that it's going to have an impact on the lieutenant governor's race this fall. And so if the DA's office has a hand in it, if they issue a report that says, well, we're going to recommend indictment of Senator Jones, it will have a direct impact on the election in November. And that's been reported in the media, numerous outlets.
Okay, so I'll correct a couple things for you. One, and I may have misunderstood how you were saying it. The district attorney's office is not authoring any report. That will come from the grand jurors as supervised by me. I appreciate that the district attorney has fashioned herself as the legal advisor to the grand jury, and that's an adaptation of the actual language of the role that that office plays. But ultimately, it's the grand jury's report, not the district attorney's. Second, and a concern we do need to cover today, regardless of how we approach the disqualification piece, would be the timing of the release of the report. I think that's something that everyone ought to leave here today with a better understanding of how that will be managed. That's within my purview, and it was helpful to have it brought to my attention that timelines could collide, that the grand jury might complete its work in October, and that might not be the best time for its work product to be shared publicly in the way that many investigative agencies, that's what the grand jury is in effect here, they hold off on taking certain steps until an election has passed, with a few exceptions, and we need to see what's going on with that report, if it's even ready by then. The grand jury is authorized to continue its work through May 1 of next year. So I don't know that it's ripe yet to worry about that other than to get a general understanding that I wouldn't be a big fan of an October surprise. So if we talk about when reports would be released and we work through a Fifth Amendment analysis, if that Fifth Amendment analysis is in light of a target letter, et cetera, Senator Jones probably doesn't need to, and it's not my analysis yet, but if the end result of that is that Senator Jones does not need to appear before the grand jury, then it strikes me that the disqualification piece is moot. I don't know from what the office would be disqualified if Senator Jones isn't being asked to do anything between now and the release of the report, other than the timing of the report, which doesn't necessarily tie into who's investigating it. If we were suddenly to switch to the Lowndes County District Attorney's Office, they finished their work with the grand jury in October, we'd be faced with that same chronological challenge.
We would, Your Honor, with the exception that of the issue that has to do with the press and the issue that has to do with the public favoring of my client's opponent for Lieutenant Governor Charlie Bailey. And the district attorney in this case has raised $32,000 for Charlie Bailey in the headliner that she hosted for him in June. Shortly thereafter, she issued my client a target letter. And then shortly after that, in fact, 2 days ago, when they filed their brief, that was the first time that it was publicly known that Senator Jones was a target of this grand jury investigation. So on one side, we have a public target, and on the other side, we have a headliner fundraiser raising $32,000. And we contend that those two things create the appearance of impropriety, that under the rules of ethics in the state of Georgia, this is prohibited conduct, and that with regard to Senator Jones, this investigation in Fulton County should be complete at this point, that this district attorney's office needs to be disqualified, and perhaps some other district attorney can be appointed. And in that case, Senator Jones would be glad to cooperate with that investigation, because he has indicated early on that he was willing to cooperate and give a statement and meet with their investigators. And then 2 weeks later, he gets a target letter. And then 6 days after he gets that target letter, and I'm getting ahead of myself.
You are. In fact, I'm going to cut you off because I simply wanted to know whether you thought it was mooted. You don't think it is.
I do not think
And
it is,
so,
Your Honor. I think that it is right at this point.
okay. Well, we may get to it. I was expecting a different answer, but I appreciate your answer. I still think we need to start with the Fifth Amendment concerns that were brought to a head in Ms. Pearson's motion. But what I want to do is start with the state on that, because your perspective, or the district attorney's office on that, because your perspective may help me better navigate what to do. And for folks in the room here, representatives of the district attorney's office and a lawyer for another witness, that witness and I have already had some basic discussions about how we might work through the assertion of Fifth Amendment privilege in certain contexts. And so we'll probably build on that. So if I'm referring to what we talked about yesterday, that's what I mean in connection with that situation. But Mr. Wade or Mr. Wakeford, what I'd like to hear from you on is your overarching reaction to Ms. Dubrow and Ms. Pearson's motion. As we've discussed in the past, I don't know that there is a blanket, I don't have to answer any questions assertion that would work here, but insofar as their 11 clients' sole connection to the investigation is their participation in the alternate elector scheme, and that was going to be the focus of 99% of your questions. If that's determined to be in light of some of the target news that's been shared, something that is protected, that they don't need to respond to, I'm not sure what the point would be in bringing those folks in a non-immunized status before the grand jury. So help me work through that a bit, please.
Yes, Your Honor. I would begin by pointing, Your Honor, to the case of State v. Lampel. That's spelled Lampl. Your Honor may be aware of this case.
Is that the Clayton County? Yes.
I believe, I'm not sure of the jurisdiction where it originally began, Your Honor, but that case speaks very pointedly to this issue. Specifically, what it says is that under Georgia law, the designation as a target without a formal charge being leveled against an individual doesn't change the ability to have someone to subpoena someone to appear before a special purpose grand jury.
Fair point. And a footnote may have been dropped somewhere in something that was provided. That's not my question. I don't think the word target is as magical in state proceedings as it is in federal proceedings, but it certainly has caused the temperature in the room to go up and antennas to go up everywhere. And so whether you call them target or you call them less of a friend, we now have witnesses who are saying, I'm not comfortable answering those questions. I think I may be facing criminal liability. In other words, I assert my Fifth Amendment privilege,
right,
or protection, whatever you want to call it. And that's what Ms. Pearson and Ms. Dubrow have done on behalf of their 11 clients. So my question doesn't target mean you can't go any further? You may want to think through in the future, labeling someone that and then hailing them in because of how this has played out. Let's just stick to the topics. If my sole connection to the investigation that you are conducting with this grand jury is that I was one of the people who agreed or was nominated or however it happened to be an alternate elector, and you're going to ask me about that, and I have a good faith basis to believe my decision to agree to be an alternate elector exposes me to potential criminal liability, why shouldn't I be able to say, I'm not going to answer any of those questions in the context of a grand jury?
I understand, Your Honor. Thank you for the clarification. I would say that the 11 individuals identified in the motion are not all situated in exactly the same place. So there may be commonality between them, but there is going to need to be an individual determination with regard to each of them. The level of involvement is necessarily individual. So what I think would work is for an individual assessment to be made in each case, since we undoubtedly have the ability under the law, under Lampel, to ask the witnesses to appear. Then there would be an ahead of time discussion between the parties with Your Honor's involvement, if need be, to discuss areas of inquiry that may lead to an invocation of Fifth Amendment rights. If that is the case, I believe we would be able to work out a procedure where there is not a badgering of a witness, but simply an ability for the special purpose grand jury to walk up to an area of inquiry, be told this is going to be foreclosed by the Fifth Amendment, and move on if there are other areas to pursue. So each of them will require, I believe, an individual assessment.
Are there any of the 11, I'm going to make it 12, I'm going to include Senator Jones in the group. So any of those 12 where the only topic of interest is that witness's participation in the alternate elector scheme?
The answer to that is no.
Every one of them, I mean, it sounds like it's a very diverse group. And one of the concerns Ms. Dubrow and Ms. Pearson brought up is that some of them are remote, some of them have trouble with mobility. But you're saying all of them have some other potential connection to the investigation or area of interest to the investigation.
Standing in my place right now, Your Honor, this is an investigative grand jury. So we are not at the stage, approaching, say, a trial where I can give a statement with the definitiveness that you might be seeking. What I can tell you is right now, can I say, well, there's only one thing that we can connect one of these people to? No, Your Honor.
Okay. So if we flip it around to the types of questions asked, you or your colleagues envision asking each of the 12, we're including Senator Jones, questions beyond simply, why did you decide to be an alternate elector? Tell me more about that. There are other aspects of the 2020 general election that you'd be asking each of the 12 about. Mr. Wade.
Yes, sir, Judge, if I might. Much like the witness on yesterday, we have planned categories to touch. And we understand, per the court's instruction, If we could narrow down these buckets, ask the general question about that particular bucket, let the witness assert. At that point, ask the witness if they plan to assert the Fifth Amendment privilege to any question concerning that issue. Once they say yes, we move on.
Sure.
Not a barrage of like 50 questions where they assert. Just to be able to hit the different buckets though, and to answer the court's question directly, yes, sir, there are other areas that we plan to attack.
There's more than one bucket for each of the 12,
Yes, sir.
is what I'm hearing you say. Okay. Well, then we would need to work through that. That helps. I appreciate that. And I think there is ample case law, state and federal, that authorizes witnesses who say up front, I'm going to assert the Fifth Amendment, to still be called before the grand jury to then assert it. Bank of Nova Scotia from the US Supreme Court was the earliest one I found, where you sometimes need to have those people get in front of the grand jury to actually invoke, because they might not when put in that situation, and that the investigators are not forced to rely on a claim that they will, or to your point, Mr. Wakeford and Mr. Wade, there may be areas that come up that aren't properly covered by that protection. I know we've been bouncing around a lot, but I think it makes sense for me to hear now from Ms. Pearson or Ms. Dubrow about the approach you've taken, which is my client shouldn't have to come in at all. And you may not yet have been able to speak with Mr. Wade and his team to know about these other buckets, to use his term, but I'll just share with you in working with Mr. Wade and his team yesterday, and a different witness and lawyer, there are other areas. They may be minor, but there's still areas where even the lawyer agreed, my client doesn't have a Fifth Amendment right not to say, this is my job. I've had this job for 10 years. And then they move on to, and what did you have to do with the elector scheme? Fifth Amendment. And then they stop. They don't go any further with that topic. But to the district attorney's office's point, it's a broad waterfront. And you have seized upon maybe the big bright lighthouse vis-a-vis your clients, but there could be some outbuildings to that lighthouse that it's appropriate for questions to be asked and, more importantly, answered. So tell me why you think instead the answer should be, you go to the extreme, it's Quash. They shouldn't even have to show up to give name, rank, and serial number.
Correct, Your Honor. Well, I think the first place to start is just to correct a few things or to clarify a few things, my understanding of what was just said. All of my clients are identically situated from a legal perspective. They were all witnesses, they were all converted to targets, and there has been no differentiation from the DA's office between that.
So let me interrupt you for a sec. So you are saying all 11 of them have received target letters or some communication from the district attorney's office that uses the T word in it?
Yes.
Okay. Whatever that may mean in the state context, but you're not, just because 2 of your clients have, you're saying they're similarly situated. It's just a matter of time for the postman to get there.
I have 11 target
Okay.
letters.
So in that way, they're similarly situated, but it sounds like they are, and you noted in your own motion, they're also very differently situated. You have, and I apologize if I have the title wrong, Mr. Schaefer as the chair of the Republican Party in Georgia. Very, very, very different role and connection to the affairs of the election than, I don't remember who is the elderly individual, difficulty with mobility and whatnot. Never heard of the person. That is a differently situated individual once you get outside of that lighthouse of, I was an alternate elector.
That's true, Your Honor, but I don't know what situation you dealt with yesterday or what that person's role was or who they were. But in my client's situation, I genuinely cannot think of a single topic or question that they could be asked that would not be either under the Fifth Amendment or a link in the chain. What's your name under these charges that they have said they're going to do by signing your name, by saying who you are, by putting your signature on something? It could arguably be, as ridiculous as that sounds, an incriminating fact. So I don't think my clients are similarly situated to these other witnesses that you're dealing with. Anything they could be asked. What's your name? That's incriminating. What's your job? That could lead to other political links in the chain. That could lead to emails where they talked about various issues. It could lead to anything. I don't see any topic that could actually be relevant to the grand jury's inquiry upon which my clients could not invoke their federal their state constitutional rights and their statutory rights. And I think absent a proffer that there is such a subject that you would agree with, that is not incriminating, 11 people should not be essentially frog marched in front of the cameras into the grand jury to be forced to invoke their rights. And I think I echo Mr. Dillon's concerns about all the publicity. You know, we're not used to that as former federal prosecutors. There's grand jury secrecy. We don't have that here. But the damage that is being done and has already been done to all of my 11 clients, and I assume to Senator Jones, is epic. And it's only going to be exacerbated. I mean, the threats that they're getting, the hate mail they're getting, the hate emails they're getting, here, Your Honor, for doing, in our view, nothing wrong. They are caught up in ambiguous circumstances, which gives them the right under Supreme Court precedent to invoke their privileges.
Okay, so we're not going to get into whether they should be surprised or not that they have become the subject of negative attention based on the decisions they made. But I'm wondering, you have now tried to put your arm around Mr. Dillon's client who is in an active contested election. I'm not aware of any of your clients being in that position as well, but again, I don't recognize all the names.
Your Honor, Mr. Sean Still is a candidate for a Senate office. In addition, Mr. Schaefer, as the chairman of the GOP, is involved in all of these, and many of these people are involved in the electoral arm of the Georgia Republican Party for many of these races. So while Mr. Jones is only involved in his race and Mr. Still is involved in his race, a lot of these people are involved in all of these races. And I think the point is, Your Honor, the ABA regulations, Georgia professional responsibility rules cite favorably with special prosecutor rules. They specifically say a target should not be put in the grand jury unless they're immunized. And here, you know, they can't immunize because there's a federal, and under the statute, they can't immunize against federal. So here, the burden really should be on them to come forward with some bucket, as you call it, that they can show we can't invoke on. And if we can invoke in all the buckets, they should not be dragged down here in front of the grand jury.
Okay. Do I need to check with Ms. DeBro as well, or you guys have an agreement that she'll speak up if there's something she wants to add?
Your Honor, you know Ms. DeBro, if she's got something to add, she certainly will, but I think I covered.
Okay. All right. Mr. Wakeford or Mr. Wade, talk to me a little bit about the last, maybe it was the second to last point I heard from Ms. Pearson about an inability to immunize. Because of course, one ticket you can punch that you may not want to punch for anyone, but you may for some of the alternate electors whose sole connection or primary connection to what you're investigating, maybe the alternate elector situation, would be to let them know nothing you say in the grand jury could be used against you. And if you put that in writing, then you magically have some compulsory powers, or I do, through that didn't exist before. But if there's not a way to provide sufficient protection, you may not have that. And I hadn't processed it the way Ms. Pearson did. Anything you want to add on that? Mr. Wade shaking his head, as in you disagree, or I don't want to add to it?
I vehemently disagree. And there's no effort or attempt or even any indication that our position would be to offer any type of immunity, I think is what she's looking for.
So I didn't hear Ms. Pearson looking for anything. What I heard her say was that even if you wanted to, and you're saying, I don't want to, the district attorney's, the scope of the district attorney's office's offer of immunity wouldn't be sufficient in Ms. Pearson's mind to protect her clients such that they could be compelled to testify. But we don't need to work through that if that's nothing that the district attorney's office is looking at right now. Okay. So then what do you see? I guess the vision you have for moving forward with the Fifth Amendment concerns, Mr. Wade, would be to have the kinds of individualized discussions like we had yesterday, and like you suggested you would have with counsel. I guess it would be Ms. Pearson and Ms. DeBro for these 11, Mr. Dillon and Ms. Clapp for Senator Jones, to talk about the buckets. In no way would I be requiring that you say, here are the 112 questions, here's our script, but it would be, these are the categories that we want to explore, and where there are disagreements between your team and counsel for the witness, then we might need to have a group discussion.
I think much like Judge, the process on last evening, we, on the day of the witness's testimony, have that conversation. If we can agree upon the buckets, great. If we can't, then Your Honor would be asked to get involved. I don't think that having a conversation well in advance of 11 people's testimony, I don't think it's fair. I think that it puts the state at a disadvantage.
Right. Okay, no, I agree. I wasn't suggesting that you had to map it out in a lot of detail or particularly far in advance, but more along the lines of what we talked about yesterday.
Yes, sir.
So I have one more question for one of the two of you. If target letter is not a reason to conclude that a witness shouldn't appear in front of the grand jury, it's a two-part question. Is it not at least a reason for that witness to have heightened concern? And if not, why send it? What was the purpose of it? If the purpose was to get them more concerned, shouldn't they be more concerned and say, wait a minute, I'm not going to answer these questions in front of the grand jury. I might sit down with you and have a proffer if it's protected, if it can be protected enough. So I'm trying to understand the thinking.
So Judge, to be transparent with the court, the discussions that took place with our side and Ms. Pearson and Mr. Bro prior to a few of their clients having interviews, voluntary interviews, the questions were, what is the status of my client at this point? We disclosed the status of the client at that point.
So it was responsive. It wasn't proactive. It was reactive. You're asking, we need to tell you.
And we said to them at that time, if at any point the status of your client were to change, we'll disclose that as well. And we did that. We'll stop there.
Okay, but so that explains why, but then help me think through what the consequences should be of that elevation in status. I assume it wasn't a downgrade that you've been downgraded from. We actually already indicted you to, we dismissed it, and now you're only a target. Why shouldn't there be the enhanced concern and the beginning of the discussion of, it may be that my client is going to invoke her or his Fifth Amendment rights here?
And certainly this discussion, Judge, from our perspective, is not an attempt to circumvent anyone's rights in terms of the Fifth Amendment. So I think that what comes of it is exactly what we're doing. Okay. It gives Ms. Pearson the right to stand up and say, this is what we don't want. And then it gives the state the right to stand up and say, Lample, Judge, Lample. They have to come in and do that. Okay.
Lample, Bank of Nova Scotia, they need to come in and assert it in front of the grand jury, as opposed to have a lawyer say, or the witness, him or herself, you know what, I've been thinking about it. I'm not comfortable doing that. I'm going to, no matter what you ask me, I'm going to invoke.
Yes, sir.
Okay. All right. Ms.
Can I respond briefly?
I was about to ask you.
Sorry.
That's all right. There you go.
Your Honor, that's not what the label says, as you accurately pointed out. It says they can subpoena people to a grand jury. And if that special grand jury abuses its power, you better bring it up at the time, or there's nothing you can do about it later. We're not going to suppress evidence. We're not going to do it. So it doesn't have anything to do with this court's authority, either under the Quash statute or the supervisory ability of this court to quash an otherwise properly served subpoena. We're not saying they couldn't subpoena us. We're saying you can quash it, and we're asking you to. I think the ethics rules are clear. I don't think, Your Honor, that under these facts, it is sufficient to drag all 11 people in here and then have them figure out the buckets. If they I genuinely cannot think of a single question or area of questioning that I would be comfortable allowing them to ask my clients, including their name, under these circumstances. And they shouldn't be dragged down here from far-flung places of the state just to be told, you know, either by you or us coming to you for 11 witnesses, however many times, that we're not going to answer the questions, they should have to come forward with at least a bucket list, so to speak, that Your Honor approves and that we set before they are dragged down here. That is not too much to ask. And if it can't be done before their appearances next week, then you can quash them and we can revisit it and we can set them for a different time. But they should not be dragged down here and put on public display for doing, in our view, nothing wrong, but through ambiguous circumstances, being forced to invoke their rights. And it's just not appropriate under the ethical standards, under the Georgia professional standards.
But if they did nothing wrong, why aren't they talking to the grand jury?
Because she's called them targets. I mean, Your Honor, we've outlined in our motion why we don't think there's even jurisdiction here, why the law protects what they did. But as you know, the Supreme Court has made clear that the main purpose, one of the main purposes of the Fifth Amendment is to protect innocent people who can be bound up in ambiguous circumstances. And I don't think we're going to find a case, at least that I've been in, where the circumstances are more ambiguous and politicized and fraught than this. And so, that is why.
I don't know that politicized makes it ambiguous, but you're using the word ambiguous. I'll let you use that word.
We certainly have different views of the facts in the law.
There are apparently different views of certain facts and non-facts. I hear you on that, but I don't know that makes things ambiguous. But I hear you, and I am mindful of, we'll call it the inconvenience factor. If in the end, the product of the exercise is to have a witness say, I assert the Fifth, and that's it. Hopefully folks will exercise discretion, but I don't think there is, other than some rules that apply more in a federal setting where the word target means something different, not entirely different, shades of meaning different. I wasn't able to find any legal precedent that said that it was improper or that the court should have barred the investigating body from requiring someone to come in their face saying, I'm not answering questions. I'm not even going to tell you my name. That may actually be something that the grand jury ought to know, is that this person won't even give her name under oath. That could be instructive to what the grand jury is doing. And they wouldn't know that if they never met the person.
Well, given that they're not supposed to draw any negative inference from an invocation, I wouldn't think that would be evidence. But Your Honor, even if it were, I think the reason you can't find any precedent is because in the federal system and in state system doesn't do grand jury work very often, so there wouldn't be precedent. And in the federal system, they don't do this. They don't bring targets in and try to force them to testify because they recognize it's unethical, as the ABA has said, and as the Georgia professional rules have outlined. And we would ask that at a minimum, Your Honor, that you ask them to proffer the buckets to you or to us before our people are brought in.
Okay. Fair request. I appreciate that.
Your Honor, may I address one point?
Hold on. Mr. Dillon, if you're going to talk more about disqualification, not yet. If it's about Fifth Amendment, you've been patient. So I'm happy to hear from Senator Jones' perspective.
Keeping my powder dry on the whole disqualification thing.
Hey, you've already used most of it, but go ahead.
No, trust me. I call the court's attention to the Georgia Code, section 1512-100, the procedure for impaneling a special grand jury and the powers of that grand jury. And under subparagraph C, it says, while conducting any investigation authorized by this part, investigative grand juries may compel evidence and subpoena witnesses. It may inspect records, documents, correspondence, and books, blah, blah, blah. It specifically excludes subpoena targets, Your Honor. And
Meaning it says you may not do that, or?
It doesn't, but because it's not included in the list, we all know the canons of construction statutes. If there's a list and it's not included in the list, it's excluded from the list. And this is the provision under which this grand jury was impaneled.
It didn't say subpoena tall people or short people. It said witnesses.
It says witnesses.
And you're saying a target is not a witness.
Target is a different category than a witness in the case law. In the state of Georgia shows that because targets are discussed differently in the Lampell case. And that's a good case to cite on that. A target is different than a witness. And this doesn't say subpoena targets. It says subpoena witnesses.
Okay. Mr. Wakeford.
Your Honor, I'll read directly from Lampell.
Lampell's getting a lot of attention. Am I right? Is it a Clayton County? It was some city council
I
person?
think so, Your Honor. I apologize. I
Ms.
don't
Green
know.
Cross is not, she's the appellate expert. She's nodding her head. All right, good.
One who has not been so charged, meaning formally charged in a formal charging instrument.
Which would be every single recipient of a subpoena so far.
Yes.
Okay,
May be compelled to appear before a grand jury, though he retains the option during his appearance of invoking his privilege against self-incrimination and refusing to testify regarding incriminating matters. This is true even if the witness is a target of the grand jury's investigation.
so Mr. Dillon stood up first, and he's freshest from saying, haha, take Lampel that way, state. So did he skip a sentence? That's a pretty powerful sentence, Mr. Dillon.
Very powerful sentence. And with regard to regular grand juries, I have no doubt that the district attorney is right. But the statute under which the subpoenas issued in this case properly is not that of an ordinary grand jury, but of a special grand jury. And it's under this chapter in the Georgia Code, and the rules are different.
So your argument is that a regular grand jury that could indict the target, Lampel says you can call that person in front of that grand jury who has the ability to indict Lampel, and he's going to have to invoke his fifth, from which they need to draw no adverse inference. But a special purpose grand jury, which can indict no one or anything, they can't subpoena a target because they use the word witness instead of target.
Yes, Your Honor.
Is the word target used in the non-special purpose grand jury statute, or is the word witness used?
Interesting question, Your Honor, but I do know that the subpoena.
What's the answer?
I don't know. I don't
Okay.
understand. I learned so much.
Appreciate the compliment.
So much book learning.
All right.
But I do know that the statute under which the subpoenas were supposed to be issued in this case is under Title 15. But the subpoena is actually rolled out under the provision in the Georgia Code that is not under Title 15. And they were in fact technically improper subpoenas because they were issued under the normal statute and not under this chapter.
So I guess they could republish them and re-sign them. And if that's the,
Exactly, and then recognize that this rule applies and not the landfill rule that they're citing here today.
okay.
Your Honor, we would take a slightly different differentiation of Lampel without.
A third read of Lampel.
It's actually the same read. That is, the sentence that he read is dicta. What the Supreme Court was saying in Lampel, we had an individual who didn't take his fifth in the grand jury, in the special purpose grand jury. The special purpose grand jury abused its authority by having him there. He was then later indicted in a proper grand jury, or I'm not suggesting they're improper, a different regular grand jury. And then he tried to get evidence suppressed from the special grand jury. This is not about whether they can compel people. We're not disputing they can issue the subpoenas. Everybody says they can. That's the only thing Lampel even arguably says. The only issue then is you get to quash them if you want to, if you believe that you should. And there's nothing that says your authority under the statute or under your supervisory authority is in any way affected by Lampel whatsoever. So you clearly have the authority to do what you think is proper with this grand jury here. And we're asking you on behalf of our clients not to have them frog marched in front of the cameras into this courtroom.
Okay.
At this point, Your Honor, I will address the original point I was going to make, which is I believe we have heard the phrase frog marched in front of the cameras 3 times now.
Right.
I do not want to talk about this, but I have to at this point. Publicity is a hindrance to the special purpose grand jury's work. I believe earlier, Ms. Pearson stated that there may have been a witness in here yesterday, but she didn't know who it was or how they had appeared or what they had talked about, which is an indication that witnesses can come before the special purpose grand jury and no one ever know anything about it. If witnesses exercise their First Amendment right to disclose after the fact or before the fact that they have been called, then they are allowed to do that. That is the source of publicity around this. It is, I think we are tired of hearing that there is being publicity ginned up by the district attorney's office in order to create a circus around this when we have actually taken pains to try to create an environment of secrecy around this. So there is no frog marching, and there are ways to come before the special purpose grand jury without publicity being brought into it. And I just wanted to clarify that point after the third time we heard that phrase.
Okay. Well, I appreciate much of what you said. I think it's a little rich to suggest that any particular side has avoided the cameras. One need look only at basically any major news outlet and you'll see who is talking to the media, and it's not always the lawyers for the witnesses. So I think everyone involved with this has taken full advantage of media coverage. That said, there are some things that can be done, I know, because I've been asked to be involved with it, to ensure that witnesses can enter the building and leave the building without much harassment from the media. And we could continue to do that. I don't know that there are many of Ms. Pearson's clients that the media would even recognize when they walked up the front steps of the courthouse, if that's how they came in. So I think the concern about putting people on public display is a bit exaggerated for most of her clients. But if there are clients who need special accommodations in ingress and egress, we can always accommodate that. We have before and we will again. So I appreciate you bringing that up. Anything more from the district attorney's office on the Fifth Amendment concerns raised in Ms. Pearson and Ms. DeBro's motion as expanded by Mr. Dillon?
No, Your Honor. We have responded to your questions. We have proposed a method going forward, and we have nothing else to add.
Okay, thank you. Ms. Pearson or Ms. DeBro, anything else on behalf of your 11 clients in connection with the Quash request? In other words, the Fifth Amendment concern?
I think that's a job.
Okay. Mr. Dillon, anything more on the Fifth Amendment aspect?
No, Your Honor, we've got the motions as we indicated earlier.
Okay, thank you. So I will not be quashing any of the subpoenas, but I will be asking, we may need to change some of the timelines. How many of your 11 are coming all at once? Are all 11 supposed to be here on the same day, or are they spread out, Ms. Pearson?
Your Honor, we have, they're all coming in the 26th, 27th, 28th. So
Okay.
Busy
3 days.
5, allocated over those days, maybe not exactly.
Okay, all right. The process is going to take longer now because what will happen, I suspect it will become more regularized and streamlined after the first few of your witnesses. But what will need to happen is that your witness and you, Ms. Pearson, Ms. DeBro, if she clears quarantine, she can be here too. She can appear virtually, however you want to make it work. We'll need to sit down, and it may just be lawyers at first. So your client, you have your client wherever you want your client to be, as long as he or she is in the building. And you're going to have that, we'll call it bucket conversation, and see where there is agreement and disagreement. And you've made very clear that you can't think of anything, not even astrological sign, because somehow that would be tied to something, or it would be irrelevant. But that conversation needs to happen so that then we can, lawyers and I can have a conversation about, is it really a complete impasse? Or I may make a ruling, and you can challenge it in whatever way you want, that witness X will need to go in front of the grand jury to answer name, rank, and serial number, and then the rest may be Fifth Amendment. It helps the district attorney's office as well, because they know basically they're going to ask one question beyond name, rank, and serial number, if I get folks past that, because there's not an area that could be explored that I don't think is unprotected by the Fifth Amendment.
So one thing, Judge, that from our side, we believe that's noteworthy is the very thing that the district attorney's office has fought so hard to do was keep our witnesses secret and out of the public eye. What Ms. Pearson just did was she gave the dates that her clients were coming in here. And that's the exact thing she complained about. She gave.
Well, before we draw more attention to this, I did not hear Ms. Pearson say, Steve Jones is coming in on this day. She divided it over days, didn't identify people. And as I mentioned, if there's a concern about getting someone in the building discreetly, we can address that and get someone in the building discreetly. Most of these folks could walk, as long as they're wearing normal clothes, they could walk right into the courthouse. And those cameras that seem to be glued to our courthouse steps right now wouldn't even pivot on them. So I think the concern is greater than it needs to be, but we can accommodate it. And I'm not going to ask anyone to get more specific about who's going to be here when. I really just needed to know, it's going to take a while for each of these witnesses because there'll be the conference before the witness testifies. Now, testimony may be greatly reduced because of the outcome of the conference. It may be that the testimony is going to be just as long as the district attorney's office had forecast, but there's still this lawyer to lawyer conference in advance. But that's how we're going to work through it. And as I said, we may develop some guidelines. A ruling I make with witness 1 is going to apply to witness 2 insofar as she is similarly situated. I don't believe all 11 are similarly situated. There's clearly overlap. They are all alternate electors. And so there's certain commonality. I assume that's why they all wanted you and Ms. Dubrow, because they're in this, besides being great lawyers, they're in the same situation. But they're not clones. And so there may be areas that are explorable with witness 1 that are not explorable with witness 2. So I'm going to let the parties develop the framework they want to use. As we go forward, I am here to assist when you reach an impasse, but I don't think it's appropriate under the case law, Lampel and others, to quash the subpoenas. But it may be that these witnesses have very, very brief appearances in front of the grand jury. We'll see how that flows.
Your Honor, just so that I understand, we're not going to collaborate ahead of time. We're going to collaborate when the first witnesses come here or in between each witness. I mean, we've got 11 people to get through. So I guess I need some clarity on how that's going to work for each witness.
So I invite early collaboration, but I also understand if the district attorney's office is reluctant to get too specific too far in advance. So they may buckle under the pressure of how long that would take as well. And there may be some basic frameworks that they want to share with you in advance, but you're now getting into the nuts and bolts that I get to stay out of. I will get in the mix should an impasse be reached. If that impasse is reached tomorrow, because you're talking about a witness who's coming on an undisclosed date tomorrow, next week at an undisclosed location, then I can talk with you all tomorrow. But it may well be that the default is let's talk when your witness is here. That may mean you don't get through everything next week. That was the reason why I was asking. If they're spread out over 4 weeks, you'd be able to do this. They're all coming in next week. I could see it being that what had been scheduled for Thursday ends up being what was scheduled for Tuesday because you only got through 2 people on Tuesday because of the conferring that doesn't occur till Tuesday. So I'm not forcing an answer to your question. I'm letting you develop it with the district attorney's office.
In light of that, Your Honor, would the court be amenable at all to moving our grand jurors, not quashing them, but moving them to later so that we can work this process out in advance?
So another really good question for you to explore with the district attorney's office. They may think that's wise and necessary as well. And it may well be that 6 of the 11 go next week because everything is taking a little bit longer because we're being careful about the concerns you've raised in your motion. But I have made clear that other than checking on the welfare of the grand jury, in other words, they're not in session from 8 a.m. to 10 p.m. I don't micromanage who gets called in or when. But I'll let you know that the district attorney's office has been flexible at having to move things if obstacles come up.
Well, we had asked for that, Your Honor, and they had refused. That's why I asked the court, but we'll talk to them about it.
Well, things are now less streamlined than they were before. So you work through that. All right. Let's talk about disqualification. Ms. Cross has moved up to the driver's seat on the DA's side. And I think since Mr. Dillon got in about 3/4 of his argument in answering my simple question of, do you think it's moot or not? I want to give the DA's office a chance to share some of their perspective about, I think the word partisan gets thrown around a lot in this, and why they think disqualification doesn't fit, or how to manage what I think are some valid concerns that Senator Jones has raised through counsel about, at a minimum, pretty clear appearance of conflict that has developed, not before the investigation started, but in the midst of it.
Well, thank you, Your Honor. I think Your Honor's choice of phrase, appearance of impropriety, mirrors Mr. Dillon's use of the phrase appearance of impropriety or appearance of conflict. And the first place the state is going to direct your attention to is all the laws cited in the responsive brief that appearance of conflict isn't enough. Under Georgia law, the disqualification of a prosecuting attorney or entity requires an actual conflict, not speculative, not conjectured, an actual personal interest in this case would be the investigation of the special purpose grand jury or in the prosecution potentially of Senator Jones. Nothing before the court suggests that that's the case. So I think that while optics in this case may be more front and center than in some others, optics doesn't carry the day. It's an actual conflict. And there's just nothing at all that suggests that there's an actual personal interest on behalf of the district attorney. I'll note that insofar as the motion targets Special Prosecutor Wade, that there's.
Oh, thank you for that. Pause on that. Mr. Dillon, do you agree? That was one of my, originally we're going to talk about just disqualification, and then Ms. DeBro and Ms. Pearson arrived on the scene, and I thought for Fifth Amendment ought to go first. My first question was meant to be, do you agree, Mr. Dillon, that Mr. Wade's purported donation, I'm not attributing anything to him, but it looks like from the records, Mr. Wade gave $2,000 to Mr. Bailey when Mr. Bailey was running for Attorney General. No donations of record or any public, insofar as a donation is public because records are made of it, no public donation support of Charlie Bailey by Nathan Wade since Charlie Bailey switched races and is instead trying to be lieutenant governor instead of attorney general. Do you agree with that?
I agree with that, Your Honor.
Okay, great. Thank you.
A whole paragraph. I don't.
It is. You don't need to cover that because that was very persuasive.
Thank you.
If that fact was true, I am focused very much on the appearance of the district attorney using that title. District Attorney Fonnie Willis invites you, encourages you to come to this fundraiser for the political opponent of the target of my investigation. That's what we need to navigate here. And I guess the question is, if there's an actual conflict, is disqualification mandatory or discretionary? And if it's mandatory, then does that mean, does the appearance of conflict still give the judge the discretion to fashion some form of relief?
Start with the last question. No.
No.
I don't think the court has the discretion. While I want to give the court as much discretion as you want to have.
Only what I should have.
Yes, I don't think the law allows the court to elevate the standard. What the legal standard is an actual conflict. And I don't believe that the court's discretion is broad enough to force a remedy for an appearance of conflict.
And examples of actual conflict that I saw in your pleading were somehow the prosecutor was able to be like a defense attorney at the same, like for the guy's brother. I mean, it was these things where, what were you thinking?
It was kind of crazy. Yeah, I represent one co-defendant as a defense attorney in a criminal proceeding, become DA, and then prosecute the co-defendant.
Okay.
That makes no sense. And that's not the situation we've got here, but that's the kind of extreme example of what the law recognizes as an actual conflict for a prosecuting attorney. It's, I represent, at one time, I represented the victim in a case that is now before me in the divorce proceeding against the defendant in the case. It's that kind of really striking in your face, and routine political support for a political ally. It doesn't make it there. It doesn't go that far.
But routine, I would interpret as Mr. Wade strokes a check for a candidate he wants to support. Using the title of your office and having on social media that you as this political office holder are holding a fundraiser for the opponent of someone that this political office is investigating. I don't know that it's an actual conflict, but I use that phrase, what were you thinking? Where the prosecutor thought I could prosecute the co-defendant of someone I defended. It's a what are you thinking moment. The optics are horrific. If you are trying to have the public believe that this is a nonpartisan, driven by the facts, and I'm not here to critique decisions. The decision was made, but if we are trying to maintain confidence that this investigation is pursuing facts in a nonpartisan sense, no matter who the district attorney is, we follow the evidence where it goes and ignore the fact that I hosted a fundraiser for the political opponent of someone I've just named a target. That strikes me as problematic, maybe not from an actual conflict level, but if we are at a cocktail party and people are asking, do you think that this is a fair and balanced approach to things? I do. Well, how do you explain this? How does one explain? I mean, that's the concern I'm working through, is that it's not a lowercase a appearance. It's like a capital A with flashy lights fundraiser district attorney for the political opponent of someone I've named the target of my investigation, where I'm the legal advisor to the grand jury, and I'm on national media almost nightly talking about this investigation. That's problematic.
Okay. Not accepting the entirety of the court's characterization of the series of events. I'm going to respond to that a couple of ways. First, still not a legal conflict. Still not anything within the court's discretion to remedy in the way that Mr. Dillon has advocated on behalf of Senator Jones. So as a legal matter, everybody can talk at cocktail parties all they want and watch the cable news station of their choosing. But no matter what, it still doesn't amount to a legal conflict under Georgia law. Second, I want to direct the court's attention to the absolute lack of any evidence in the case that any action taken during the course of the investigation has been politically motivated at all. As the court, I think, referenced, maybe I'm paraphrasing, but it's the grand jury subpoena to Senator Jones, not the district attorney's office. The district attorney is the legal advisor to the special purpose grand jury, but and may well have an investigation of their own, but Senator Jones is trying to fight a subpoena to the special purpose grand jury, and it was brought under their authority.
It was, and I think technically you are correct. I wouldn't want anyone to be misled that the special purpose grand jury is the only, meaning those grand jurors are the only source of subpoenas, that they say to their legal advisor, here's who we'd like to see next. That can happen, but what can also happen, and doesn't matter how it happened here, because your point is a good one, but I don't want people leaving here thinking, oh, it's only the special purpose grand jury who decides who comes in. Equally so, and perhaps most of the time, it's the district attorney's team that says, here's who we would like to have come before the special purpose grand jury next. That subpoena comes through the grand jury, maybe under the wrong statute on the subpoena, but it comes through the grand jury. But the idea and the motivation and the decision is from the district attorney's office. I don't know how Senator Jones's subpoena, which channel through which it flowed. I've got an inkling, but it doesn't matter. Your point is a good one. I don't know that it cures the concern about political support for opponent not having any bearing on how focused or not the special purpose grand jury would be on the person I'm supporting's political opponent before November X, whenever the election is.
I understand, and I didn't mean to imply otherwise to the public in general. I was directing my argument to the court, but I certainly understand the need to clarify that. But the larger point being, though, that I think in this posture, it would be Senator Jones or Mr. Dillon's obligation to point to some action taken during the investigation that supports the allegation of a political motivation, and you just haven't seen it here. Yes, sir.
Mr. Dillon will get a chance to say more, but part of his introductory remarks, he emphasized a whole lot. Then this target letter arrived, like there was some cause and effect. And I'm not familiar with the timeline, and you mentioned that my description of events may have gotten some of the timeline wrong, and I'm not anchored to any particular timeline other than the correct one. And hopefully there's only one set of facts as to the timeline. What was your reaction to the way Mr. Dillon was painting? It was almost a cause and effect timeline, that X happens, and as a result of X, support for Charlie Bailey, then Y happens, something that in the public eye would be negative to Senator Jones.
I'll represent to the court, and I believe it's accurate, that all of the target letters went out at the same time.
Okay.
So it was not pegged to any event that have any relevance to the lieutenant governor's race or any other political option. It was dictated by the terms and the pace of the investigation and nothing else.
So the 11 that Ms. Pearson and Ms. DeBrow received were issued on the same date or effectively the same time as Senator Jones.
Yes.
It's not Senator Jones got his on a special date and it was a broadcast event and then the other 11 went out. Okay.
It was a routine issuance of a change in status, as Mr. Wade explained, in an effort to be transparent to everyone who had been working and talking with the state and the state. The final point I think I kind of want to make is that, as noted in the brief, we have partisan district attorneys and partisan elections for those offices. And so it should surprise exactly nobody that elected district attorneys have political affiliations with other individuals in their same political party. And I think the Post case, I've got a copy for the court if you're not entirely familiar with it, and a copy for Mr.
What's the site?
It is 298 Georgia 241. It's a 2015 decision. It's Post, P-O-S-T. I've got a copy that's highlighted. I'll hand Mr. Dillon. The same portion is highlighted for the court. Can I click, please?
Sure.
Thank you.
And on page 5, it's just a reference. The case doesn't raise the issue of a prosecuting attorney who's been sought disqualification by a defendant or a target or a subject or a witness in the case. It's an even higher standard of what a judicial recusal would be. And I think it's instructive is that it's a lower standard a lower burden and a higher standard for a recusal of a court. And in this case, it was the situation where the district attorney had been listed as a campaign official of a Superior Court judge's campaign at one time. And the court in that case found, well, that's beyond routine, that's beyond financial, that's beyond what you normally expect. I'll note and so the court concluded, you know what, when you got that allegation in the affidavit for the recusal, you should have sent that on. I'll note too, though, that once it was sent on, the court ultimately determined that that wasn't an actual conflict of the court, and it went right back. So I bring the language to the court's attention because it does draw a focus on these are things that happen when you have political affiliations for elected offices. It's expected, it's normal, and until or unless you can show some actual conflict, then that's just maybe the upside, maybe the downside, but that's just a consequence of the system that we have.
Okay.
One final thing, and I think maybe this could streamline some of our other conversations about remedy. State's not interested in any October surprises. That's not, I couldn't source that October deadline to anything. I'm unable to determine when that is. I don't believe that that's I think it's exceptionally unlikely. That
No, my understanding from speaking with the grand jurors directly in my supervisory role is that the timeline is whatever the timeline is. There is no deadline. They'd like to be done really soon, but that's only because they're giving much of their life to this process. But they'll follow this process as it unfolds. And as I intimated to Mr. Dillon, and I'll make it clearer when we wrap up with the disqualification discussion, if the work is completed such that it lands on or near the election, it will stay completed and in my office until it gets disclosed after the election.
you won't be hearing any objection about that from the district
I
attorney.
didn't think so. And I never heard a request to the contrary. What I have heard is we don't know when it will end because that's what I get. Hey, when will we be done? When we're done.
I got passed a note that's going to clear up that timeline.
Mhm.
The political event for Mr. Bailey was June 14th, and the target letters were sent to Senator Jones, among others, in the July 5th, July 6th timeframe.
All right. So 3 weeks later. Okay. All right. Mr. Dillon or Ms. Clapp. I'm happy to hear what you want to share. Don't repeat what you already said, as I heard that. I'd like you to start with Ms. Cross's focus on, and it is different. I'm very, very familiar with the judicial requirements and the impact and effect of apparent conflicts. And Ms. Cross's observation is The district attorney is not a judge. This is true. But because of that, the apparent conflict may be an area of concern that we ought to talk about, but it would not empower me to take any remedial action, only if there were an actual conflict. And you may say there's an actual conflict, and I'll hear about that. But I don't disagree with you if you say there is an appearance of a conflict. You don't need to try to convince me of that. If that's not enough legally, then we'll all agree that there was an appearance of conflict. Hopefully something like that doesn't happen again between now and the conclusion of at least this electoral cycle. But that's what I need you to start with, is appearance versus actual, and then anything else you needed to cover that you didn't already, I'll hear from you.
Your Honor, if I may, my associate has a PowerPoint, and we'd love to plug into the screens if that's possible for the court.
It is. Ms. Clapp is part of the Zoom session that's going, and you're able to share your screen. Is what you're going to share something you shared with Ms. Cross, or is this brand new?
We have not shared this with Ms. Cross, but
It's not evidence, it's argument.
we do
Okay.
have some exhibits, Your Honor. We do have some evidence here today.
Okay. Well, if there's going to be evidence, let's just make sure Ms. Cross gets a chance to see it before
Absolutely.
you
Absolutely.
blast it on the screen.
Oh, no, it won't be blasted on the screen. It won't be published before,
Okay. Are you doing okay? Okay.
So as an initial point, Your Honor, I'd like to point out that Senator Jones received his grand jury subpoena in late May. And he was set for testimony in late July, and we won't go into the date because we don't want to create a bottleneck. But he was assured by the DA's office on several occasions that he was a witness in the case. And he was glad to do his civic duty. We were trying to work out the parameters for a voluntary interview to avoid the reptile marching. I won't use that term because while I like it, I just won't.
So, but what you are avoiding is answering my question. So my question was appearance of conflict versus actual conflict. What do you think the law is, and where do you think this falls?
I think, based on my reading of the law that controls in this area, that when there is a public perception of a conflict, then there's an issue that this court has to look at. And the standard is the standard that's laid out in the Young case, the Supreme Court case that the DA cites in their response brief.
Young as in not old?
Young as in not old.
Okay.
And I don't have the site in front of me, but
I'll get
it's
it.
also in my brief.
It's
We
a-
both like the Young case.
like lamp old. Okay.
Okay. The DA cites it for the proposition that the standard of neutrality for prosecutors is not necessarily as stringent as those applicable for judicial or quasi-judicial officers. And she is correct. Direct quote from Young, it is not as stringent.
Oh,
But
but
the
it's
court-
on the screen.
The court goes on to say that the difference in treatment is relevant whether a conflict is found. However, not to its gravity once identified. We may require a stronger showing for a prosecutor than a judge in order to conclude that a conflict of interest exists. But once we have drawn that conclusion, we have deemed the prosecutor subject to influences that undermine confidence that a prosecution can be conducted in a disinterested fashion. If this is the case, we cannot have confidence in a proceeding in which the officer plays the critical role of preparing and presenting the case for the defendant's guilt, or hear the defendant's recommendation for a charge. And so here is the Supreme Court saying that if the confidence is undermined, if the court is saying, what were you thinking? Then the decision is already made. Because if we have a what were you thinking factor, then even if they recommend his charge, and even if they indict him, and even if they go to trial, and even if they win the case, which we submit will never happen, error has occurred under the Young case. But the bigger issue here is not whether or not they can indict him for submitting a false document. They determine the falsity of all documents in this case. The issue here is whether or not they can drag Senator Jones down by merely releasing to the press that he's a target. This guy gets $32,000. This guy gets a publicly disclosed target.
So you're going a little off the rails for me
I
here. The focus here is disqualification, and I'm not quite sure what you're invoking from the press or who you think said to the press that someone was a target, maybe other than you or your client talking to the press, but that's not what your motion was about. Your motion was about the decision the district attorney made to support someone in her political party.
Yes, Your Honor.
And how that may create, I think does create the appearance of possible conflict, but is it an actual conflict? And you're helping me process young that maybe appearance would be enough. But that's what I need us to focus on, and not your theory that the district attorney's office is trying to affect someone's political career, as opposed to revelations about someone's connection to a series of events that are particularly controversial in our society right now might prove problematic for that political candidate. I can't help that part. Those were choices that were made. They might elevate that candidate in the eyes of some. They might not elevate that candidate in the eyes of many.
It may, Your Honor. And with regard to those facts, as I stated earlier, Senator Jones was willing to come in and meet with the prosecutor and sit down and say, these are the facts in the case.
Okay.
Under oath, not under oath. But then they received this carpet bombing of target letters for everyone who signed the document. And so suddenly 16 witnesses had the door slammed in their face because they were told that they were less friends of the investigation or targets. Could we go to the next slide? So Mr. Jones received his target letter on July the 6th, as the DA indicated. Contrary to their motion, where they indicated he was a potential target, he was told he is what? Next slide. You are advised you are a target of the grand jury. This is on July the 6th. Next slide, please. On July the 12th, 6 days after I received this target letter, and I will say that we consider this to be highly confidential, and the only two people in the world who knew about the target letter were me and the district attorney's office. I get this unsolicited email from a reporter with Yahoo News that
Stop
says,
for a sec. Stop.
So I'm sorry, this isn't a document that I've seen before. So before we publish it,
Right.
Mr. Dillon, is that something?
yes,
that we
forgive me.
Can you take that down, Ms. Clapp, or go to the preceding page? So you had assured me.
Yes, I did, Your Honor, and in my zeal, I got ahead of it.
All right, be less zealous. Represent your client, but let's not slap emails for which no foundation has been laid up on the screen. I thought you had said, I know you said, don't worry, the actual exhibits I won't put on the screen. They'll just be in my hands and they won't be published. But
I had a carefully drafted script, and I'm off script because we started in the middle of my argument. May I approach and present the court with a copy of
you may.
Well, if it's a copy of defense exhibit number 2, again, there's no foundation for this document. I haven't seen it before.
I'll take it. I won't necessarily make it part of any
Okay,
record.
That
but
was my request. Thank
if
you.
we're gonna have a discussion about it, I need to be able to see it. Thank you. Do you need one? This is two of the same thing.
Yeah, an original and one, Your Honor.
Okay. All right. Anyway, your representation is that you're free to share with me what happened in your life. And in your life, a reporter out of the blue reached out to you saying, hey, I've heard that your client is a target of the district attorney's investigation.
Yes, Your Honor.
Or the special grand jury's investigation.
Mhm.
Okay.
3 days later, this same reporter broke the story. And we won't publish that either because
Good.
it's not an exhibit and it's on the internet. So with leave of court, we'd love to publish the story.
You're free to do that, not through the court Zoom.
Okay, so we'll hold off on that slide for now. But I will represent to the court that 3 days later, this same reporter broke that everyone who signed on the alternate slate of electors had received a target letter, including Senator Jones.
So assuming for a minute that's exactly how it played out with you and Mr. Isikoff. Where does that get us? Actual conflict, apparent. I understand why your client is very frustrated by that. You suggested, gosh, the only two people on the planet who should know about it would be the district attorney and you. Certainly, it's a whole lot more than that, because you know the district attorney didn't all by herself write these letters. In fact, she didn't sign the letter. It's on the screen right now. Mr. Wade did. So the universe has just grown by 50% because it's three people.
Right.
So
When I
somehow word, let me finish.
Yeah, yes.
Somehow word got out, and the reporting universe knows about it now, and it flows, and as an unwelcome development for your client. Actual conflict, appearance of conflict. I need you to bend it back to what I need to work through, which is, should I take any remedial action to address an actual conflict or the appearance of a conflict, if I have the authority, if it's an appearance? That's what we're working through, and not the trials and tribulations of Senator Jones because there was a leak. Unless you've got proof that it was Charlie Bailey who leaked it, and then, that's a bad, now we've got.
That would be that. Yes, Your Honor, that would be.
But you don't have that.
I do not have that. I
Right.
have no indication that Mr. Bailey was involved in this. All I know is that this organization knew, and I knew, and of course, my client knew. And then 6 days later, this internet reporter knows. And then shortly thereafter, there's an AJC story. If we could, I'd like to publish Exhibit 3, which is the flyer for the fundraiser.
That's in your pleading, so that's, yeah, you may, it's already public record. Well, let me make sure the state can look at it. If it's been doctored, they shouldn't, but if it's what's in the pleading, it should go up.
It appears to be what is in the pleading. We don't have an objection to the authenticity of it.
Okay,
May I approach, Your Honor?
I've got it on my screen.
Okay.
I'm good.
So we have this fundraiser, and it's a blockbuster. Headlining Fannie Willis, the district attorney. In fine print, you can see that Charlie Bailey is in fact the candidate there, but the font's so much smaller that I have to squint to see what it says. This occurs about 2 weeks before the decision is made to make my client target in this case. The district attorney, according to publicly available records, which I have marked as Exhibit 4,
A different form of what was in your exhibit.
this wasn't attached.
This is new.
This is new. This particular document, Your Honor, is from the Public Campaign Finance website here in Georgia. So this is publicly available data. It shows during the day of and the day after this fundraiser, $32,000 went into the coffers of Mr. Bailey. We submit as a direct result of this fundraiser. I'm told that the custom is often people show up with a check or they give their regrets and send a check the next day. During this particular month, Mr. Bailey raised over $270,000.
So this was a particularly small fundraiser for him.
It might have been a particularly big one. This might have been the one that caused the avalanche of checks to come in.
Could be for all those people who are checking the ethics website to see what's the cash flow looking like for the first couple of weeks. Do I put my money behind this horse?
This is the sort of headline fundraiser that gets people to say, oh, okay, well, we have a big wheel. We have somebody who's on the nightly news, as this court notes, that's pulling for Charlie Bailey.
Okay.
So one candidate in the lieutenant governor's office or the lieutenant governor's race gets a headliner. The other one 3 weeks later gets a target letter. Quietly gets a target letter. Now, there were numerous news stories speculating about the existence of target letters on or about the time of the Yahoo News article. And there was a lot of buzz about that. In fact, there was even an AJC story where DA Willis was quoted as saying that numerous attorneys had received target letters on their behalf, but didn't name Senator Jones, unfortunately. In fact, it wasn't publicly known that Senator Jones received a target letter until the DA filed their brief 2 days ago. They were the first people to acknowledge he was a target of this grand jury. We had never acknowledged that. It was a mere speculation in the press. But it's that sort of thing that gives the DA the ability to benefit their friends and harm somebody who's under investigation. And that's really what we're talking about. So the cases that the DA points to in their motion from 1916 and 1936 are talking about transactions where the financial transactions were $150 and was that material? And while those are interesting cases, and certainly $150 was material in the Depression, when we're talking about $30,000 and we're talking about swaying an election, a statewide election in Georgia, that's a significant thing. And this is not something that's being done by accident. This is being done by design. This fundraiser was pointed at benefiting Senator Jones' opponent.
I mean, isn't that the purpose of the fundraiser? I mean, I agree that the point of providing, the question is, does the district attorney's decision to support someone with whom she's politically aligned, surprises no one that they're politically aligned, does that rise to the level of creating an appearance of conflict? Maybe. I've opined on that a bit, an actual conflict. And I understand, because you can't climb into someone's mind. You have to do a little of this through the shadow boxing of, well, look, there was the fundraiser, and then all this money came in, and then there was the target letter. Do you have more of a dot connection than one preceded the other?
As far as a direct connection?
Any connection?
It's what is out there in the press. It's what is out there in the ether, and it's continuing to evolve. And so, part of Senator Jones' concern is that, well, this report is going to come down in October. Glad to hear there's no October surprise, but there've been this whole series of drips, this whole series of leaks out of the Fulton County DA's office that have tilted benefit towards Mr. Bailey and pointed to my client being a presumptive violator of the law. And it's only because the DA has the authority to do that.
So when
this court, forgive me,
I didn't mean to interrupt you. Finish.
This court were to determine that she has a conflict and this appearance is sufficient, it would go to the Attorney General's office to appoint a new prosecutor with regard to Senator Jones, who could sit down with him and say, well, Senator Jones, we're interested in what happened in December 2020. Would you like to talk to us? And just as we did on day one with the DA's office, certainly we would be glad to. Do we have a target letter from your office? No, you do not, Senator Jones. We would be glad to talk to you because we have useful information that would aid your investigation, because this is an investigation, when it was impaneled, that was supposed to gather evidence to see whether or not there was an effort to undermine democracy in this country. And when Senator Jones said, I have a subpoena here, I'm going to go talk to these people, we said, fine. We prepared our witness. But then he got this target letter. And so everything changed, just as it did for these 11 clients. So where initially they indicated that they wanted to gather evidence, now it appears that really what they want to do is gather publicity. And they slammed the door on all 16 witnesses who signed the document by giving them target letters. And then they announced that they're all bad people. And in essence, they're going to recommend their charges in this report if and when it comes to your desk.
So the DA's office doesn't write the report. The grand jury does. Just to repeat, you mentioned something about the district attorney's office leaking this and leaking that. Supposition or evidence?
I certainly don't know that the district attorney's office talked to Yahoo News, but I know that I was the only other person holding a copy of that target letter on that day. So it's a res ipsa thing.
Okay.
And there are numerous daily stories in the AJC that quote learned sources from inside the investigation And the only learned sources from inside the investigation are the people that are conducting this special grand jury.
I'm focused on your client and I'm asking you to direct me to anything other than the gentleman from Yahoo who said, I've heard X about your client being a target. Has there been other outreach from the media to you saying, I've heard Y, I've heard Z about Senator Jones that you can source only to the district attorney's office, as opposed to, hey, any witness who comes before that grand jury is free to talk to the media afterwards if he or she wants to.
It's absolutely correct. And as you know, that's how grand juries work.
Right.
They're supposed to operate in secrecy, which is what was anticipated when this was founded. But the witnesses are free to go talk. And some of the witnesses probably do talk. But certainly Senator Jones had an interest in the public not knowing that Fulton County considered him a target. So
Right.
he did not talk. We know
Okay.
that. The leak of the existence of this target letter and subpoena actually violate the canons of ethics that the district attorney operates under. And one of the things that we have with regard to Exhibit 5 is the ethics training that the DA's office gets from their general counsel, Mr. Robert Smith, who is the general counsel for the Prosecuting Attorneys Council of Georgia. And with permission of the court, I'd like to mark this as Exhibit 5.
No
I think
objection.
the district attorney offered me an affidavit from Mr. Smith earlier today, so I think they rely on him as an expert in regard to ethics.
Okay.
And so with this time, I would offer Exhibit 5 into evidence and request to publish it.
Sure.
Well, Your Honor, I don't object to the submission of the document. I can't verify his authenticity. If Mr. Dillon is representing to the court like the source of this information, where he got it, that it's accurate, true, and complete, then that's probably going to take care of my objection. I just can't look at it and know that this is the presentation that Mr. Smith gave.
Right. It's too long for you to do that just in this setting. Any reason we should be concerned that this has been altered in any way, or it's anything other than what Mr. Smith presented to not just this district attorney, but presumably all assistant district attorneys and their bosses around the state?
My understanding is that this is his presentation and he does periodically, and he would have done it during the time period that Ms. Willis was the district attorney here.
Okay.
Can I ask for a representation of where you obtained this PowerPoint?
This is
presentation?
available on the internet.
Did you pull it off the internet?
Yes, I did.
Okay, the PAC website, and I'm sorry, I
No,
don't,
you have to have access to the PAC website to get it.
and I'm wondering how you got it.
It's out there in the ether, so.
He got it from Yahoo.
I got it.
Well, then I kind of thank you for your
Would you
candor.
like to show it to your client? She would have attended this training and see if it's complete.
I would like to reserve publication of the document until I can ascertain whether it is true, accurate, and complete, because I understand that it has been sourced to the internet, and that's not something I can accept as authentication.
So it's admitted. I'll take it. Just don't put it on the screen. I want us to
We
keep
won't
moving
put
forward.
it on the screen now. It does quote the rules of professional responsibility in Georgia. And so I think those rules are relevant. They're relevant here. And the fact that the district attorney's members and the district attorney herself receives training on this to be reminded on a periodic basis of what their responsibilities are as prosecutors is relevant.
Okay. So are you going to be reminding her now by reading them?
I would love to just read a few snippets, if I may, Your Honor.
If they're truly snippets.
If they are truly snippets, that the DA and assistant DAs should refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. And that's Rule 3.8.
So, but this relates to your theory that there was a leak that isn't necessarily in one, we don't know there was a leak. Two, that the district attorney herself, who is the focus of your concern because of the political support she had for someone with whom she's politically allied, that she somehow has been behind the leak that I guess would have been the fact that your client's a target. But there's no evidence of that.
There was no evidence that my client was a target until 2 days ago when they said it in their reply brief, Your Honor.
Okay.
And that was not inadvertent. That came directly from the mouth of the district attorney's office. And so we're not talking merely about this runoff. We're talking about the fact that it is publicly confirmed that Senator Jones is a target of this grand jury,
Okay.
irrefutably.
So your focus is not on a theory that it got out, but the confirmation, if you will, in Ms. Cross's response to your motion to disqualify.
Yes, Your Honor.
Okay.
And so that
I'll
brings us.
let her talk about
Oh, yeah,
that.
yeah. I understand. But that brings us to the juncture that you pointed out where we began, which is on one side, we have this headliner and we raised 32,000. And then on the other side, we have this target letter that they publicly disclose. And we have these series of leaks to the press. And this is an effort to sway the outcome of the election for lieutenant governor in this case. It really has nothing to do with whether or not they ultimately indict Senator Jones or the other group of 11 or anybody in this case. Because once the publicity machine has done its business, the friends of the district attorney have won. And that's really why we're here. And so if you ask, is there a real conflict here? It couldn't be more real.
Okay. Short of disqualification, what do you view as a remedy? If I conclude that something needs to be done, and I have the authority to do it, but I don't think that it's practical or appropriate to say that the entire district attorney apparatus for Fulton County has to unplug from any investigation, questioning of, exploration of your client's connection to interference with the 2020 general election. What do you see as an intermediate step? One would be for me to say there's an apparent conflict, but I can't do anything about that because I can only handle actual conflicts. Another would be to say either it's an actual conflict, I'm going to do something, or I'm going to go out on a limb and do something even though it's only an apparent conflict. So if I'm going to do something, but it's not disqualify the whole office, what is your second most preferable outcome?
Well, as the court is aware, there are not numerous special grand juries of this magnitude to point to for precedent. And so what we suggest in our brief is that the statutory provision that requires, once there's a conflict made apparent, that it be referred to the Attorney General Carr's office, and he finds someone to conduct that portion of it here, independent of the special grand jury. And it could be as simple as finding a district attorney that doesn't have, find a good, solid Democratic district attorney somewhere that doesn't have a conflict, and give him the authority to pursue Senator Jones' issue in this. And we will be glad to sit down with him. We will be glad to approach him with the same willingness to say, let's get to the bottom of this issue of whether or not there was a conspiracy to undermine democracy in this country, because that is an important issue. And let's put the media circus behind us. So let's answer the questions and forget affecting this election for lieutenant governor, because there's no way that she can keep a hand in it.
She meaning the district
She
attorney.
being the district attorney, forgive me, Your Honor, and not affect the outcome of this election for lieutenant governor.
So if Attorney General Carr selected fictional district attorney X, who had also given $2,000 to Charlie Bailey's campaign for lieutenant governor, problem?
Would not be a problem at all. That's an ordinary contribution, and it's exactly what Learned Counsel points to here. Now, if they had hosted a fundraiser during the time period that they were investigating Senator Jones, I might have to go to that judge and talk about that fundraiser.
What if that district attorney had already hosted, that district attorney is not involved in the investigation. She hosted a fundraiser 2 weeks ago, 50 grand, earn even more money than DA Willis, but it's done, overdone with, and says, you know what, I'm not going to do any more fundraisers from here on out, because now I've been tasked with seeing what connection, if any, Senator Jones had to what was going on in November and December.
If every district attorney in the whole state had hosted a fundraiser for Mr. Bailey, then that issue might be apparent. But I suspect, given the list of good Democratic district attorneys in this state, that we could find somebody who doesn't have a conflict and hasn't hosted a fundraiser for either one. Because certainly if somebody had hosted a fundraiser for Senator Jones, the Attorney General shouldn't nominate that person either. Find somebody who doesn't have a dog in the hunt. Danny Willis has a dog in this hunt.
Got it. Thank you, sir.
Thank you, Ron. Can we offer into evidence?
Can you take
Exhibits
down
1 to
the
5?
screen thing?
Actually, I was going to ask him to leave it up.
Oh, leave it up. Don't take it down. Oh, too late. Thank you, Ms. Clapp.
So can we offer into evidence 1 to 5, Your Honor?
If there's no objection, 1 through 5, was 5 the one where the provenance was the internet?
Yes, I'm going to object to the authenticity. I believe the foundation has been shown for exhibit number 5 to be entered into evidence. So I didn't object to the court reviewing it, but I do object to it being tendered and admitted.
Why don't we do this? I will take 1 through 5, and then I'll give Mr. Dillon an opportunity to maybe shore up his sourcing of it. And if, in fact, it's pretty clear it was Smith was the name of the Mr. Smith's presentation, then I'll add 5 to the other 4. I'll hold on to it, but it won't become part of the record until either Ms. Quash, you agree, hey, I talked to Mr. Dillon a little bit more and we see the source, or we're substituting for it the one that I don't know that you can, someone can get off the PAC site.
All right, but I don't, I do want to raise objections to some of the others if they're being tendered now into evidence. Exhibit 1, the letter, I don't have an objection to that.
Okay, 1 is admitted.
Exhibit number 2 is the email that I do have an objection to that being tendered and accepted into evidence without any provenance of it. I do also object to the relevance of it. There's nothing in this email that sources any information to the district attorney's office. And insofar as it's being offered to show that the leaks are coming from this side of the table, I object to the relevance of that. I don't think that shows that, and I object to the admission of it.
Okay.
Number 3 is the fundraiser flyer that's up on the screen now, and we don't have an objection to that being tendered and admitted into evidence. Exhibit number 4, again, I have objection to the relevance of this. I don't think it shows what, at least it's been argued. It's identified and been offered for the purpose of establishing how much money was raised at the fundraiser. But what the actual document appears to be, based on Mr. Dillon's representation, I don't have any reason to doubt it. This is publicly available information about how much money was donated to Mr. Bailey's campaign during a 2-day period. It's not at all sourced in this document to the fundraiser. And while we might suppose some or all of it was related to that, I don't think that's been shown. And because of that, I have an objection to the relevance of it.
Okay. And then 5 is being conditionally admitted, provisionally admitted. I'm assuming you can clear up the sourcing.
Yes, sir.
All right. Anything you want to add, Mr. Dillon?
No, Your Honor.
I will admit exhibits 1 and 3, and then 5 will be provisionally admitted. We'll see if the loose ends can be tied up there. Last question, Mr. Dillon, and I'll let you sit down. Beyond the Young case, is there a case or are there cases you want me to look at that stand for the proposition that the appearance of a conflict could be sufficient for a judge to take any of the forms of remedial action that you're seeking?
Your Honor, I rely on the Davenport case. And that is a Georgia case. Forgive me. Do you have the sign for that?
I don't see it in you're free to rely on it. It didn't manage to make its way into your motion.
It's in mine.
Oh, okay.
Page
You guys
4.
share very well when it comes to cases.
The site is a 157 Georgia Appeals 704. It's if that's the case you're referring to, a 1981 case.
Okay, do you agree, Ms. Cross, that discusses, there's Davenport, actual versus apparent conflicts?
I didn't cite it for that proposition, and that's not my recollection of the
Okay.
discussion in the case.
I'll look at it anyway.
Yes.
Okay.
Yes.
Okay.
Your Honor, I never did get clarity on the basis for the objection to Exhibit 2, other than she objected to it.
Relevance was one, and I think it was foundation, although I mean, the recipient was Mr. Dillon. I think he could authenticate it as receiving it, but I'm not sure the relevance. You suppose that Mr. Isikoff theorized what he did because the district attorney's office let him know about it, as opposed to a witness from the grand jury or a grand juror. I don't know who's in the circle of discussing who's going to be a target or not. But you've made your point, and those who are following this have made the point. I'm just not going to make it part of the record.
Okay, and with regard to Exhibit 4, the financial fundraising report, we offer that as Mr. Bailey's take over the 2 days, the day of the fundraiser and the day after, and we submit that it is relevant.
Okay. I thought it showed his take for the whole month.
No. It's just a 2-day period.
And it is before and after the 14th?
It is the day of the 14th and the day after.
Okay. And it's publicly available?
Yes, it is, Your Honor.
I'll admit it.
That was Exhibit 4.
Yes.
May I offer a copy to the court? I'm not sure I did that earlier.
What you'll want to make sure is that the court reporter ultimately has them. I've got number 2 up here. And when we're done, we'll do that. Court
Okay.
reporter's busy doing what she does. So
Yes,
just
Your
make
Honor.
sure before you go that our court reporter has 1, 3, and 4. And then 5 you're going to hold on to until you and Ms. Cross can work out, if you're able, the origin story for that.
Yes, Your Honor.
All right. Ms. Cross, your closing thoughts about disqualification.
Very brief ones. Giving Mr. Dillon a chance to.
Thank you.
Your Honor, if we're taking a look at now what has been admitted as Mr. Jones Exhibit 3, you'll notice that Mr. Jones is not Mr. Bailey's opponent at this point in the lieutenant governor's race. If anybody's got a problem or was the opponent of Mr. Bailey at that time, it's Mr. Kwanzaa Hall. Because at this point, Mr. Bailey was in a runoff election, and it is very clearly identified as the district attorney, Willis, raising money for Mr. Bailey in the runoff fundraiser.
It's the
It's so-
largest font on the page,
It-
even larger than the district attorney's name, is runoff.
Runoff. So I understand it so far as we're talking about appearances. I think that shifts the focus a little bit. The district attorney is not raising money for the opponent of Senator Jones in giving this fundraiser. This is prior to Mr. Bailey becoming the actual lieutenant governor nominee for his party. So I want to make that as clear as it can be.
When was the runoff election?
Sometime after June 13th.
Good.
Yeah, someone with easier access to Google might be able to.
Yeah.
The last week of June,
Okay. Late June.
late June.
Got it.
All right. Mr. Smith is going to be so pleased because he gets another mention. I've shared with Mr. Dillon an affidavit from Mr. Smith, who is actually general counsel of the Prosecuting Attorneys Council of Georgia. May I approach, Your Honor?
Yep.
All right. I've got an original for the court reporter, but I'll hold on to that until it's under admitted. This is an affidavit that I shared with Mr. Dillon, not long before the hearing, but a few months before the hearing. Just identifying that Mr. Smith is someone who deals with conflicts, who routinely advises district attorneys, solicitors general, and other entities who make inquiry about the legal requirements and what amounts to a legal conflict for individuals prosecuting attorneys. He's reviewed the motion, he's reviewed the response. The motion of Senator Jones included the runoff fundraiser flyer that we're still looking at. And he determined, in fact, in his opinion, it is not a legal conflict. I'm not suggesting that Mr. Smith's opinion supplants the court's, But insofar as the individual who routinely advises district attorneys about these matters, this is the individual saying that on these facts, there's not an actual conflict. There's also some language in there indicating, of course, that he does advise that an actual conflict is required as opposed to the appearance of one. So we'd ask that State's Exhibit number 1 be admitted.
Any objection to States 1 being admitted, assuming Jones 5 ultimately gets admitted?
Maybe that's a fair exchange.
Yes, Your Honor, I'm going to object subject to Jones 5 being admitted along with this.
Okay.
I have no reason to doubt the authenticity of this, but Mr. Smith also trains them on the ethical rules. And so, we could be back here next week with a motion for prosecutorial misconduct, which I'm loath to file. But the ethical rules also apply to the district attorney's office. And in the presentation that I provided the court, he lays out exactly the rules that DA Willis's office has violated.
Okay, well,
I'm sorry.
sort out Exhibit 5 soon, so I can put that alongside. I'm going to admit DA 1 or States 1, but I'd love to see 5. It seems like it ought to come in, but I understand the state's concern. I bet they're navigable.
I think we're going to be able to work that out. And if there comes a time when the court considers Senator Jones' offer of Exhibit number 5, Mr. Smith's presentation, I believe that at least the excerpt that Mr. Dillon read this afternoon was a concern or admonishment or flagging the extrajudicial statements of a district attorney or a prosecuting entity. You've heard no evidence this afternoon, or to my knowledge in the record anywhere, that there has been any extrajudicial statement from the district attorney's office about Mr. Jones that has played a part in this. Insofar as the objection this afternoon came to the identification, apparently for the first time officially, that Senator Jones has received a target letter, of course, that was in direct response to the motion to disqualify that was filed by Senator Jones on Friday. They raised in that motion equal protection and due process claims. They reference constitutional protections of the federal and state constitutions. And they're essentially saying, hey, look at what you're doing. You're investigating me, and you're doing that only because I am a political opponent of someone you like. That's our whole point here, right? That's the whole thrust of it is friends get rewarded, enemies get punished. The fact of the matter is, and what the district attorney represented in defense of that was, no, you're just like everybody else. You're treated exactly like everybody else, similarly situated to you, receive the same treatment, you can't show otherwise. And for that reason, the legal standard hasn't been met. So I wanted to clear that up too. Otherwise, I'm happy to address any concern or comment further from the court, but I think the burden hasn't been satisfied. There's not a legal conflict here and the motion should be denied. After I consult very briefly.
Please consult.
My table, thank you. About the thing?
Can we take the screen share down now?
Yeah, we can.
Thank
And
you.
apparently we can withdraw our objection to Exhibit 5. That's
Great.
no need to go further.
So before you leave, Mr. Dillon, make sure a copy gets to our court reporter, but I'd like a copy of 5 as well.
I'm handing out the original of the affidavit.
Thank you. Thanks. Mr. Dillon.
Very briefly, Judge. With regard to the last point raised by the state,
Which was,
that it was perfectly okay to out the target letter status of Senator Jones in their pleading.
I didn't hear that it was perfectly okay. It was an explanation for it, that it was, the hand was forced because an argument is made, we're being treated differently. And so I didn't hear perfectly okay, but it was a justification. You don't think it's justified because?
I think they could have made that argument under seal and not furthered the appearance that they're favoring Mr. Bailey and trying to do what? Hold my client up to public ridicule and increase his shame and do the things that Mr. Smith's presentation says they should never do.
Ms. Pearson, was there anything you wanted to add? Your motion with Ms. DeBro was styled motion to quash and disqualify in name only. I mean, your focus was quashal, and I get that, but you adopted Mr. Dillon and Ms. Clapp's motion. You've shared with me that Mr. Still is a political candidate. I appreciate that Mr. Schaefer is politically prominent in the Republican Party, and you said all of your clients are active in one way or another. What's the disqualification argument? They seem to be not in the same category as Mr. Dillon's client.
Your Honor, I would agree that Senator Jones has the most direct conflict. In our view, not to ask for more relief than the senator himself has asked for, but in our view, that remedy is not sufficient to address that conflict, and the conflict is exacerbated. The evidence of the conflict is exacerbated by the politicization of our clients' cases and our clients' processes. And
So
we think
I have to have you explain what you mean by politicization, given what it was your clients were doing. What is politicizing their political activity, their political choices, their connection to a political party? What's politicizing about it other than talking about that which is inherently political? I'm not following.
I think it's a great distinction, Your Honor. We're not talking about that we're talking about political things. We're talking about political motivation by one party against another party, and to actions taken in one uniform direction against Republicans, prominent Republican candidates, prominent Republican actors.
Was there a third group of alternate Democrat electors in case the Democrat I'm not aware of another group that the special purpose grand jury should be investigating in connection with Republican efforts to create Republican alternate electors and to challenge the outcome that at that time and continues to show that a Democrat won. Because it's this whole, I was going to press Ms. Cross on it, but she didn't go there with partisan, because partisan has lots of meanings. I don't think the partisan, in the cases she cited, was Democrat and Republican. It was, I'm partisan because I'm trying to get this guy prosecuted. I have a stake in the outcome of this prosecution. That's not where argument went today. But everything about this is inherently political because two political parties collided. Someone appears to have won. The folks who appeared to have lost didn't like that outcome and said appearances can be deceiving and took some steps. And the question is, were those steps legal? And that's what the special purpose grand jury is investigating. So it seems to me utterly unremarkable that your clients are all Republicans. What would be remarkable is if they weren't. So what's the politicization? Because I don't want to miss it if there's a reason to be concerned, but you're not asking, I hope, for we have to have a Republican district attorney investigate this because that's the only way it'll be fair.
No, not at all, Your Honor. I think the process outlined in Mr. Dillon's motion is that the Attorney General would be allowed to designate the replacement. And so we think that that should be done because I think the appearance of impropriety with Senator Jones takes the entire DA's office for the entire investigation, not just with regard to him as the remedy that I'm trying to say. But you are correct that our focus was quashal and that we are joining in that motion as an add-on. I would also say, Your Honor, that just on behalf of my clients, you asked if there's another slate that they should be investigating. And I would argue under the authorities that we put in our motion, to the extent we were contingent electors, so were the Democrats, because there was this pending judicial challenge that made it a jump ball. And so, yes, the answer to your question is both electors were contingent at that time, contingent on the judicial outcome, which never came.
Okay, I appreciate that perspective. But you did say you are seeking, I'm paraphrasing you, more relief or greater relief than Mr. Dillon was seeking. Mr. Dillon, but then I thought you ended by saying we want what Mr. Dillon recommended, which is push for his client, Senator Jones' situation, to the Attorney General and let the Attorney General decide, should I, the Attorney General, find another district attorney and her office to see if it merits having a conversation with Senator Jones or investigating or sending a letter or whatever they choose to do. That's what's the difference between that and what you think I ought to do in terms of disqualification and your clients?
Your Honor, I think that disqualification, if there is one, it is disqualification to the entire investigation. It cannot be, the disease cannot be cabined to Senator Jones alone, because
Okay.
it's still the special grand jury being advised by this district attorney, and the report would still be advised by this district attorney. And so we don't believe that's a sufficient cure, and that if there's a disqualification, it should be from the entire investigation, not just from Senator Jones.
Got it. I follow that better. Thank you so much.
Just as a suggestion, Judge. and-
Yes.
And I point to, actually, my learned counsel points to my own brief at page 6. The McLaughlin case, McLaughlin v. Payne, indicates that when the elected district attorney is wholly disqualified from the case, everybody in the office is. And so here, the special grand jury really has two focuses. It has, one, the focus of the call between the president and the Secretary of State's office, and perhaps other officials that related to finding the votes. That's one aspect of it. And then there's this other aspect of it that could be carved off and sent to Mr. Carr's office to say, let's find a new district attorney who doesn't have a dog in this hunt and do an investigation, do a proper investigation. They could still have this other aspect of it, but a new district attorney could come in and look at the other aspect.
So without agreeing that there are only two aspects to what the special purpose grand jury is investigating, your creative idea is if I determine that there needs to be disqualification, it could be not as to individuals, but as to subject matter. And so this question of an alternate slate of electors, if that is something that needs to be further investigated, create a separate entity to do that, that's not supervised by this district attorney.
That's correct, Your Honor.
Okay, thank you. All right, I think we've covered everything, but let me find out from Ms. Cross, Mr. Wade, Mr. Wakeford, anything else from the district attorney's office?
Nothing, Judge. Thank you.
Okay, Mr. Dillon or Ms. Clapp, anything further from Senator Jones's legal team?
No, Your Honor.
All right, Ms. Pearson, Ms. DeBro, anything else from the 11?
No, Your Honor. Thank you.
All right. So we're clear. Some things I'll need to memorialize in writing. I am not quashing the subpoenas. I'm repeating myself now, but it merits repeating. I will be issuing an order, a written order on the question of disqualification. And it will address not just Mr. Dillon's client, but Ms. Pearson and Ms. DeBro's clients as well. I'll probably put in there a little bit about the timing of the issuance of the report, but I want to make it clear now in front of everyone what I've heard from the district attorney's office as well. There is no plan for there's no plan for a date right now anyway. It's not knowable. If the way the investigation flows, insofar as it stays with this district attorney's office and this special purpose grand jury, that grand jury disgorges its final report somewhere near the election, it will not be published and released until after the election. I'll put that in writing as well. I just don't think it's ripe yet, because from my brief conversation with the grand jurors, just checking on their health and well-being, they don't have that light at the end of the tunnel yet. But things could change. And if suddenly their work is done, I will make sure that there is a meaningful time buffer between release and election. And it may well be that we need to publish the plan. If it's going to be released, if the report is going to be released before the election, we make clear when that projected date is, so that if people have concerns or objections, they can file those and we could air that out before there'd be a release. I'd be shocked if there is a report before then. I'm trying to pry an interim report just for me from them on how things are going. How do we type it all? How do we do that? So we'll see how that goes. I appreciate everyone's time. And with that, you all are free to go.